Hello, everyone, and welcome to today's presentation on an overview of paid family leave laws in the United States, presented by Equileave. So in this video, what we're going to cover is kind of the landscape of what paid leave looks like in the United States today. As we're going to see, it varies a lot state by state. It's not something that's controlled at the federal level. In this presentation, what you're going to learn is kind of an overview of what to look for in paid leave laws in the states where you operate. We're going to focus on the benefits available to employees, when those benefits are available to employees, and what you should know as an HR leader, a payroll administrator, or someone else who is dealing with the kind of smorgasbord of paid family leave laws in the US. So let's get started. Let's begin with a little bit of base kind of Leave 101 history so we can all sort of start from the same spot. So leading up to 1993, the federal government and states didn't really have much in the way of laws that would give people time away from work on a paid or unpaid basis or on a job protected basis. So if an employee was going to be absent for pretty much any reason, as long as the employer wasn't discriminating in violation of some law, it could choose to terminate the employment of individuals and not bring them back after the end of their leave period. Employers could have, of course, policies or collective bargaining agreements that would provide for leave, but they weren't really legally required to under any circumstances. That all changed drastically in 1993 when Congress enacted the Family and Medical Leave Act, commonly known as the FMLA. So the FMLA provides up to 12 weeks of unpaid leave to eligible employees working at covered employers when they experience a qualifying event, which could include bonding with a newborn or newly adopted or fostered child within the first year of the birth or the placement. So that's a lot. Let's unpack that a little bit. So the FMLA provides up to 12 weeks off of unpaid leave. So an employer does not have to pay an employee during the course of their FMLA leave, and usually the employer will not pay the employee during the course of an unpaid FMLA leave. Maybe the employer will allow the employee or even require the employee to use up some PTO or sick leave or something like that, but otherwise the leave can be unpaid. 12 weeks is the duration of leave an employee is entitled to each year under the FMLA, and that year can be measured in a number of different ways elected by the employer. Usually like the employer will employ like a backward looking calculation where it looks at the amount of leave the employee has taken in the past 12 months and then allows the employee to take up to 12 weeks at a time. That kind of prevents leave stacking. We're not going to get into that too much into this video, but note also that FMLA leave is not available to every worker in the United States working at every employer. There are really three requirements for someone to be able to go on an FMLA leave. Number one, they have to work at a covered employer. Number two, they have to be what's known as an eligible employee under the FMLA. And number three, they have to experience an FMLA qualifying event. And so again, not to go into those too much, but just to understand how leave law works in the United States. First, an employee has to work at a covered employer. In the private sector, that usually means an employer with 50 or more employees on a consistent basis. So if an employer is a small business and always has under 50 employees, none of those employees are going to be able to use FMLA leave because the statute only applies to employers with 50 or more employees on a consistent basis, essentially. There's a bit more nuance to that definition, but if an employee is working at a covered employer and that first requirement is met, the employee still may not be entitled to use FMLA leave. The second requirement is that the employee must be an eligible employee to take FMLA leave. What's an eligible employee? Well, there are three requirements for that. The person must have worked for the employer for 12 months. The person must have worked 1,250 hours for that employer within the past 12 months. And then there's the worksite requirement. So an employee must work at a work site where there are 50 employees within a 75-mile radius of that work site. Probably a requirement that was added essentially to ensure that an employer could move people around to have the right coverage because it's got enough employees in that particular area and near that particular work site to cover the work when people go on FMLA leave. So those are the requirements to be an eligible employee. So if an employee is working at a covered employer and the employee is considered an eligible employee and meets those three requirements, all of them, then the employee can take FMLA leave when they experience a qualifying event. There are a couple different qualifying events under the FMLA. We're not going to talk about all of them on this call. They can include, though, bonding with a newborn, having a baby, or bonding with a newly adopted or foster child. That leave must be taken within the first year of the child's birth or placement. So a parent can't say, gosh, I have this child and I want to go to their college graduation. They're 18 and I want to take that time off. No, a parent can't do that for bonding reasons. Maybe a great reason to bond with a child, but the FMLA doesn't provide any leave on that basis. And again, the FMLA was intended to provide a job-protected right to unpaid leave. So an employee can't be discriminated against for using FMLA leave. The employee can't be discharged for using FMLA leave. That's protected time off, essentially. Usually an employer would be able to discharge an employee for being gone for 12 weeks, right? But under an FMLA leave, if someone qualifies for that, then their leave is protected, their time off is protected. The time off can't be the reason for discharge. It doesn't immunize an employee from being discharged for other reasons unrelated to the FMLA leave. However, it does immunize them from being discharged for the fact that they took that time off that was protected by the FMLA. So again, that's an unpaid leave. Since the FMLA has passed in 1993, there's been a movement and interest in providing, in particular, new parents with paid time away from work in order to promote a work-life balance. And so over the years, Congress at the federal level has considered a variety of paid family leave proposals that would apply all throughout the United States and require certain employers to provide certain employees all across the United States with leave on a paid basis. None of those proposals have gained enough traction to be enacted. There's still interest in them and they're still discussed from year to year as Congress considers different ideas for how to do this. One popular one is for Congress to consider saying, hey, we're going to have a federal paid leave law and they're not going to be state family leave laws anymore. We're going to preempt those state family leave laws and just have one uniform law that applies all across the United States. That's been a popular kind of idea as more states pass laws, but the federal government has not passed any law that applies all throughout the United States. So what has happened? Well, in the absence of any federal law on this topic, a growing number of state legislators have gotten together and said, hey, we think there should be a paid family leave law. We think that people should be able to take time off in order to bond with their newborn children and to get that time off on a paid basis. And so those states, many of them have been successful at enacting paid family leave laws that provide time off on that basis. And so as a result, we don't have one single law in the United States that provides paid family leave all across the country. But what we do have is this kind of growing patchwork of states that increasingly are enacting laws that say, hey, within the borders of our state, if you're an employer, you have to provide paid time off to employees when they are having a baby or bonding with a newborn child within the first year of birth. And so in some states, an employer is going to be required to provide that time off. In other states, the employer is not going to be required to provide that time off. So continuing with kind of the history of paid family leave laws in the United States, this slide has a list of states that have enacted paid family leave laws, and this is constantly changing and evolving. By the time you watch this webinar, there may be more states to add to the list. But for now, these are the states that have current laws in place or states that are enacting laws that will go into place. The laws usually go in place within a year or two after the legislature enacts them. Of course, regulators need time to figure out how the laws are going to work and how they're going to administer the laws. So there's a delay between when the laws are enacted and when they actually go into place. And let's dig into this list a little bit and see what it tells us. So here I have the states and the effective dates when their laws went into effect or are going into effect. And you can see with the first one listed, even in alphabetical order, not only is California first in that alphabet, but it was also the first state chronologically to enact paid family leave. And that's kind of common generally. You often see that California is on the forefront of passing laws that create new workplace protections and new workplace benefits that are greater than what is provided under federal law. So here in 2004, California was the first state to say, hey, we think that people should get paid family leave when they're away from work because they are bonding with a newborn child. So in 2004, California became the first state in the nation to provide for time off work on a paid basis. And it was well ahead of the curve. As you can see, it took more than 10 years for the most part for other states, for entirely actually, to get kind of on that bandwagon and say, hey, us too. We also think that there should be this new employee benefit that we're going to provide within our states. So today, what we have or are soon going into place are paid family leave laws in California, Colorado, Connecticut, DC, Maine, Massachusetts, Minnesota, New Hampshire, New Jersey, New York, Oregon, Rhode Island, Vermont, and Washington. So what do you notice about these states? Well, they're coastal for the most part, and they are generally states that are on the forefront of providing for employment protections and more progressive employment benefits than other states comparatively. So, these are states that, again, have decided, hey, the FMLA isn't enough. Unpaid leave for new parents isn't enough. We're going to have some kind of paid family leave program in our state. An important thing to note is that there is no sort of model paid family leave law. What these states generally do is they look kind of at the other states that have passed paid family leave laws and they say, well, we're going to write our own. We're going to make it work for us in the way that we think will work for us. And so what we're going to talk about throughout this video is how all these states really have vastly different paid family leave laws with vastly different provisions, and they operate in some ways similar ways, but the devil is in the details, and all the details are different when you jump from state to state. So the one city on here I want to mention with an asterisk on there is San Francisco. In 2017, San Francisco enacted a paid family leave ordinance. As we'll see, what it requires is that employers in San Francisco supplement for their employees in San Francisco the amount of benefits an employee will receive from California during a paid family leave in that state. And so California has a paid family leave law that it enacted in 2004, and it provides for partial wage replacement benefits from the state for employees who are on a paid family leave. So as we'll see, California, with those benefits, isn't going to provide an employee with 100% of what they normally make. It's only going to provide for a percentage of the employee's wages. And so as a result, San Francisco said, hey, we think employees should get 100% of their regular wages. We think that's what's fair. So employers, you have to supplement what California is paying to those employees, and you have to pay those people something more. And so we'll talk about that in other videos, but it is a requirement in San Francisco, and it's kind of a unique thing in that San Francisco is the only city on this list with that kind of ordinance, and the only place where people are going to get 100% of their usual pay guaranteed by statute or ordinance. So we'll talk about more how leave supplementation benefits work in this video, but that's something important to note. Okay, so how do these laws work? Let's get the general flavor of what happens when a state passes a paid family leave law and how those laws operate in the states where they have been enacted. So the laws generally provide broad coverage to all state residents for the most part. There are some restrictions, but generally the laws are going to be very broad. Certainly the coverage is going to be broader than what you get under the FMLA. So after a state passes one of these laws, what the state does is they impose a tax on people and employers in the state. And as the state collects those taxes, they put the taxes towards funding their paid family leave program. So after the program gets funding, after the law has been enacted and they've got the money coming in, at some point, the state is going to allow employees to apply to the state fund for wage replacement benefits when they are away from work for a qualifying reason, which always includes bonding for a child. That's always a reason for which someone might qualify for paid leave benefits in the states that have enacted these laws. So again, the state is going to create a pool of money and people can apply to the state for those benefits. That's important. Paid family leave laws as enacted in these states do not require that the employer pay out the benefits. Instead, they require that the employer pay taxes to the state and that the employees withhold taxes to the state. And that varies from state to state how that works and who's paying what and in what amounts. But after those programs are funded, the employees apply to the state for the benefits. So it's kind of like unemployment insurance benefits managed by a state, or in some states with state disability programs, it's like that. It's money that the state has. So an employer doesn't really have to make payments when someone goes on a paid family leave. It's already made the payments in the form of taxes of some sort, or the employees already made the payments in the form of tax withholdings. So that's important to note, that these laws don't really require the employer to provide paid family leave. They just require the employer to participate in the program, to allow people to take leave, and then to help the employee in the process of applying and getting those benefits. Now, even though the employer doesn't have to pay those wage replacement benefits, it's important to note that in almost every state and with almost every paid family leave an employee goes on, the employee isn't going to get 100% of their usual salary or hourly rate times the amount of hours they work each week. Instead, the state is going to pay some percentage of benefits, some percentage of the employee's regular wages to the employee. And think about the purpose of that. You know, if you had someone making a ton of money, the state doesn't want to pay out a ton of benefits to that person to get them up to their regular pay. Instead, what the state is trying to do is to ensure that everyone who goes on a paid family leave has some kind of minimum income coming in to support themselves. It's really a social safety net. It's not meant to be a windfall for anyone, or to allow people with extremely high income to get extremely high benefit payments from the state. So again, the state is only going to pay out, in almost all cases, a portion of a person's compensation that they usually receive, not 100% of their regular compensation. As a result, employers have a choice. If they want to, they can supplement the amount of benefits an employee is going to get from the state. And so that's something important to note, and an important consideration an employer is going to have to make in designing their paid family leave program if they want to have one. And spoiler alert, that's the area where EquiLeave helps employers. We help employers come up with payment plans so that they can know how they should properly supplement those benefits employees are going to get from their state insurance programs. Another important thing to note is that state laws may provide job-protected leave, or they may just provide a wage replacement benefit. So California is an example of this. California's paid family leave law doesn't actually say an employer has to provide paid family leave to an employee. It just says that if an employee is out and away from work during the course of bonding with a child within the first year of birth, an employee will be eligible to receive benefits from that state-mandated and administered insurance program. It doesn't actually say, hey, employees, you have a job-protected right to leave. Accordingly, nothing under those state laws in California would really prevent an employer from replacing an employee who goes on that kind of leave. But here's the thing to note, that it's important to note that there are other laws that very often kick in and would provide an employee with a right to be on leave in those states. So the California Family Rights Act, the Family and Medical Leave Act that we talked about earlier, the Pregnant Workers Fairness Act, a number of laws might kick in and give the person a job-protected right to be away from work. And so in that way, these job protected leave laws and these state kind of insurance programs, we can think of them as, work together and hand in hand. One of them provides the money and one of them might provide a job protected leave right. In addition, an employer's policy might provide an employee with a right to be away from work on a paid basis. So that's important to note so that you can kind of understand the limits of what the law is providing. A key thing that you should walk away from after watching this presentation is that each state paid family leave law is different. There is no model state paid family leave law. All the states have decided to enact their own laws that kind of work for their states and work differently in their states. So realize that there's going to be key differences. So first, note that there are different employer coverage thresholds and employee eligibility criteria. But remember what I said earlier. These laws are intended to provide benefits pretty much to everyone in the state. So in almost all cases, someone's going to be eligible and their employer is going to be covered if they are in a state with a paid family leave law. The scope of these laws is incredibly broad. It's broader in every state than the FMLA, for example, that has that kind of employer coverage threshold and that employee eligibility threshold. States with paid family leave laws have decided to be much more liberal in allowing employees access to these benefits, but there can be different employee eligibility criteria from state to state. For example, in New York, someone has to have worked for about 6 months or 180 days with their current employer before they can be eligible for those paid leave benefits. In California, after the employee has earned $300 from which state taxes have been withheld, they're eligible for the benefits. So that in that state, I mean, that's a really low eligibility threshold. Someone's going to be eligible for paid family leave almost as soon as they enter in the state and work for one pay period for an employer. So it's important to note, though, that different states have those different criteria. In addition, some states have provisions that will exclude employees from eligibility for paid family leave benefits. So what I mean by that is that in some states, for example, someone might not be eligible if they engaged in fraud against the paid family leave program. In that case, they may be excluded by the state if they tried to get benefits fraudulently in the past. So those aren't going to apply very often, but some states have provisions for that. Another key difference from state to state is that different states with different paid family leave laws provide for different amounts of paid leave. And it varies a lot from state to state. In California, they provide currently 8 weeks of paid family leave. In New York, it's 10 weeks. In Oregon, a state with a newer paid leave statute, they've extended it to 12 weeks. In Rhode Island, it's only 6 weeks. Rhode Island and California on the lower end there were states, again, that were earlier on in enacting paid family leave. States that have come in later to the game have kind of upped the ante for the amount of paid leave available. So you kind of see a trend of states with new laws being more generous. And that's something that happens very often in employee benefits laws like this. California or a state like that will lead the way and kind of set the lowest bar and say, hey, this is what we think people should get. And then other states look at that and say, hey, we think that's a great idea too, but we're going to one up you. We're going to provide even more and even greater benefit to people. So, hey, watch what we're about to do here. And then they pass a law that provides for a greater benefit. So Oregon and Washington came along after. States like California and Rhode Island enacted their laws. Rhode Island at 6 weeks provides the least amount of benefits for any state. It's interesting that in Rhode Island, there's discussions about increasing that amount and lobbying to increase that amount. You can read about that online. And so by the time you watch this video, Rhode Island may have increased the amount that they provide. But generally, again, because they were earlier in enacting one of these laws, they provide for some of the lesser benefits in comparison to the states that have enacted laws that have come in later. Washington has gotten a little bit more nuanced with theirs. So it's a good example of another approach to the amount of paid leave a state can provide. Washington will provide a different amount depending on the employee's circumstances. So an employee is going to get in Washington 12 weeks of leave for bonding with a newborn child. An employee also could get 16 weeks of paid family leave if they experience more than one qualifying event. So for example, if an employee has time to bond with a child and then needs time off to care for a family member with a serious health condition. Those might be qualifying events under Washington law. And Washington says, hey, we understand that you might have two things happen within a 12-month period. So look, if you bond with a baby for 12 months and then you experience that other need for time off, we're not just going to say, well, you exhausted all of it for that baby, so you don't have any right to time off. No, Washington says, hey, we understand that if you have more than one qualifying event, you can take up to 16 weeks off for the combination of all those different qualifying events. In addition, Washington provides up to 18 weeks of paid family leave if the employee experiences a pregnancy or birth that causes them to have an incapacity for some time and they're unable to return after 12 weeks. So it's possible in Washington that someone could get up to 18 weeks of paid family leave in a 12-month period, depending on their circumstances. There's another real difference in approach with respect to these paid family leave laws that you should be aware of. So in most states, all employers are required to participate in these laws. It's not an option. So taxes are going to be withheld from employers and employees. They're going to be put into that fund, and employers have to allow employees to apply to that fund and get those benefits and to take the paid family leave. In a couple of different states, they've said, hey, we don't necessarily want to require employers to participate in this benefit. So here's how it's going to work. If employers want to voluntarily elect to opt in to our state paid family leave program, then we will collect the taxes from the employer, we'll create the fund, and employees only at that employer will be allowed to take advantage of the benefit. So employers can opt in those states. Vermont and New Hampshire are examples of states with those kind of voluntary employer participation programs. In addition, it's notable that in some states, employers can elect to satisfy their obligations under the paid family leave laws by maintaining their own private insurance plans that provide for wage replacement benefits. So New York's an example of that. In New York, you can say, hey, we want to go ahead and participate in New York's program. Or you can say, we have a private insurer that we want to use, and maybe we use them for some other stuff, and our life's going to be a little bit easier if we manage paid family leave through our own private insurer. So instead of paying into that paid family leave program, we're going to make payments to a private insurance company, and our employees, when they need to go on leave for a qualifying reason, can apply for leave through that private insurance company instead of applying to the state. And the private insurance company will administer the benefit and make the payments to the employee and overall manage the entire program. So employers in most states have an option to allow a private insurance company to manage those paid family leave benefits, and an employer can elect to do that if that's the approach that they want to take. In addition, in different states, there are different reasons why an employee might qualify for paid family leave. So again, in every state, an employee, if they qualify, can take time off to bond with a newborn or child placed in adoption or foster care within 1 year of the birth or the placement of the child. In other states, an employee might be able to take off due to a serious health condition. That kind of leave may be provided under the paid family leave statute, or it may be provided under a state disability insurance program or law. In addition, in some states, employees can take time off due to the loss of a child. In some states, an employee can take time off due to domestic violence concerns. That's known as state leave. And in some states, that's provided on a paid basis. In other states, it's provided on an unpaid basis. In addition, in some states, an employee can take time off on a paid or unpaid basis due to family needs connected to military service. So again, the qualifying reasons why someone can take a paid family leave will differ from state to state, and even within these bullet points, the circumstances under which someone can take a leave are going to depend on what the law says and what it provides for. So if you're in, a state with one of these laws, you kind of need to know what are the reasons why someone might be able to qualify for that leave. But in all of them, remember, bonding time is included. So each of these state paid family leave laws provides for leave on that basis. Here's something really complicated. Each state differs when it comes to the amount of the benefits that are provided, the value of those benefits, and how the benefits are ultimately calculated. So it's going to work a little bit differently from place to place. Each state calculates a weekly benefit amount that an employee will be paid during their time away from work on a paid family leave. And in every state, the state isn't just saying, hey, what's the employee's hourly rate or what's the employee's salary? We'll pay some prorated amount based on those numbers. It's never that simple. Instead, states each have an individualized formula that's going to look back at the employee's earnings over some period of time. And then it's going to average out those earnings to kind of a weekly benefit amount. And then it's going to pay the employee some percentage of that weekly benefit amount up to a maximum amount set by the state. So why aren't the states just saying, hey, we'll pay the hourly rate times the number of hours worked, or we'll pay the salary prorated for the amount of time off? Well, the states aren't doing that because they want to account for bonuses, commissions, and those extra payments that ultimately make up an employee's total compensation. They want to say, hey, we understand that, an hourly wage or salary really doesn't tell the full story about why some employees are paid what they are. Ultimately, some employees rely very heavily on those other payments like their commission and their bonuses. So in calculating the amount that someone's going to get on a paid family leave, we're going to make sure those are included so that the employee ultimately could potentially get more than their hourly rate or salary. But again, we don't want employees to get a windfall. What we're trying to provide is kind of a livable amount of money that's going to support the person financially and give them that social security safety net while they are away from work for a paid family or medical reason, or for bonding leave in every state. So we're going to cap it. We're going to only pay a percentage of that weekly benefit amount that we calculate, and we're going to cap the amount at some maximum weekly benefit amount. So again, states are going to look back at a certain period of time and kind of average that out to a weekly benefit amount. They're going to calculate a percentage of that weekly benefit amount, and then they're going to pay the person up to a maximum for a particular week. And that maximum is going to differ by state and is different and set by the state and their regulators. So let's look at that a bit closer. So here's an example of how California calculates the weekly benefit amount that an employee can receive during the course of a paid family leave under California law. So the first thing that California does is it looks at the employee's earnings during what it calls the base period. Almost every state uses a base period as that first step to calculate their weekly benefit amount. And they're looking at the total earnings during the base period. So just what was the total amount, gross amount that the employee made before deductions during that period. In California, the base period is the first 4 and the last 5 completed calendar quarters before the employee takes leave. So if the employee is taking leave, say, in December of the current year, the employee is taking leave in quarter 4, right? That's where December falls in the calendar quarters. So what you do is you figure out what are the 5 completed calendar quarters before that. Well, it's the completed calendar quarters so far before December are Q3 of this year, Q2, Q1, and then in the prior year, Q4 and Q3. And what the calculation does is it looks at the employee's earnings during the first 4 of the last 5 completed calendar quarters. Well, what are the first 4 completed calendar quarters? Well, it's Q3 and Q4 of the last year, and then Q1 and Q2 of the current year. So what you need to do is you need to figure out what the employee made during those 4 quarters, each of those 4 quarters, and then and identify the wages by quarter. Because in the next step, what you're going to need to do is identify the single quarter that has the highest earnings. So which of those 4 quarters in the base period in which the employee made the most money, right? What you're going to do is once you identify that quarter, you're going to perform a calculation. Now, before I get to that calculation, just note, different states use different base periods. Most of them use a base period calculation like this that looks at those calendar quarters. Some of them might look at the 2 highest earning calendar quarters. Some might look at all the wages during all 4 calendar quarters. It's going to vary from state to state, but in California, what you're going to do is you're going to identify the quarter where the employee made their highest earnings during the base period. Then you take that quarter and you look at the total amount that the employee made in that quarter, and you perform one of 3 calculations that depend on the amount the employee made. So if the employee, and these are 2023 numbers, they change every year based on inflation, but in 2023, what you would do is you would look at what the employee made in that highest calendar quarter. And if the amount is less than $929 in 2023, then the employee's average weekly wage that they could earn during a paid family leave is $50. If the amount is between $929 and $7,154, then the average weekly wage is 70% of the employee's wages earned in that quarter divided by 13 up to the maximum. Why do they divide 13? Because again, there are 13 weeks in a quarter, so the state is trying to get to that average weekly wage. So the average weekly wage, you're going to take the highest quarter earnings if they're in between 929 and 7,154, and you're going to divide them by 13 to get an average weekly wage, and then you're going to multiply it by 70%, and that is going to be the amount of the employee's weekly benefit amount that they could get during a paid family leave. Now, what if the employee earned more money? What if they earned more than 7,154? Well, you're going to do the same thing but multiply by a different number. You're going to get the average weekly wage by taking that highest earnings quarter, dividing it by 13, and then you're going to multiply that by 60%. And that's going to be the employee's weekly benefit amount. So you can see if the employee makes more, the state's only going to provide 60% of the wages. If the employee kind of makes in that middle tier, the state is going to provide 70% of the employee's wages. Again, which tier they qualify for depends on their total weekly benefit, their total calendar earnings in that calendar quarter and where they fall in those ranges for 2023. Again, those ranges are going to change from year to year, so otherwise the calculation should stay the same, but the ranges will change. The maximum in 2023 was around $1,620. So if one of those three calculations gave you a weekly benefit amount of greater than $1,620, then the employee would earn $1,620. If those calculations gave you a number less than $1,620, then the employee would get that weekly benefit amount that you get through those calculations. So again, there's a maximum amount, and that maximum amount also changes from year to year. So the maximum in 2024 in California is going up to $1,698. And so that's important to note, that it changes from year to year. Now, note $1,698, if an employee is getting that maximum, that means they're actually making more than that. And so they're not going to get 100% under any circumstances almost of what they're going to make week to week. And so you as an employer have a choice about whether you want to supplement those benefits by providing more money to bring them up to 100% of their pay, but you can't just pay them 100% of their pay. You have to subtract out the amount that the employee is going to get week to week from the state of California. But that's how you get there, and that's kind of how California is going to do those calculations to determine what the employee is actually going to be paid by the state during a paid family leave. Now, most states use a base period calculation, like the one I just showed you in California, of some sort. They all vary a little bit, but New York uses a different process. So let's look at New York just as another good example of how this can work. Well, if an employee on New York is receiving short-term disability insurance from the state, then they can get a weekly benefit amount that is 50% of the average weekly wage, up to a maximum of $170. That 170 number does not change. It is set by the statute. So unless New York changes the statute, someone can only get $170 from week to week in state disability insurance benefits. Now, New York's paid family leave statute provides more, and the numbers do change from year to year. So when someone is on a bonding leave in New York, their weekly benefit amount is 67% of their average weekly wage, up to $1,151.16 in 2024. That number moved up. In 2023, it was around $1,131, but now it's more. So that's for a bonding leave in New York. But how does New York calculate the employee's average weekly wage? It's not the same as in California. Remember, in California, we looked at that base period, got the highest quarter earnings, divided by 13, and then multiplied by 60 or 70%, depending on where the employees, where their wages fell for that highest earning quarter. In New York, their look-back period doesn't look at a base period and calendar quarters. Instead, New York looks at the last 8 weeks before the employee is taking leave and says, figure out, what the employee's average wages were during those last 8 weeks. And so if the employee got a big bonus in those last 8 weeks, that's going to be included. So New York is basing it on those recent wages. And in New York, the weekly benefit amount calculation can vary because New York says, hey, take the last full weeks if that's most beneficial to the employee, or include that partial week when the employee goes on leave if doing so would result in more money for the employee in terms of their weekly benefit amount. And so you have to calculate both the employee's pay during the last 8 weeks, and you must calculate it during that partial week off, and then ask yourself which of those two, when you average them out and divide by 8, is giving you the biggest weekly benefit number. Take that number, that's the employee's weekly benefit amount, multiply it by 67%, and then ask, is it greater than $1,151 or less than? If it's greater than $1,151, that maximum in 2024, then in 2024, the employee is going to get the maximum amount. If it's less than that amount, then the employee is going to get their average weekly benefit amount that you just calculated. So again, you can see how the amount is different and calculated differently in a state like California and in a state like New York, and it's different everywhere. Again, there is no uniform law in all these states. They've all passed their own laws and used their own methods that work for the state. And so that can be really difficult for an employer if you're trying to kind of determine what employees are making from state to state. You need to know all the aspects of these calculations to really understand and see and discern what it is an employee is going to get in terms of their weekly benefit amount. So to sum it up, each state has a different formula for calculating the weekly benefit amount. Each state has a different maximum weekly benefit amount. We saw in 2024 in New York, it's $1,151. We saw in California, it's $1,698. So California makes a higher maximum available to people in that state than New York does to people in New York. We saw that in calculating that weekly benefit amount and the average weekly wage, each state uses a different base period potentially. Each state pays a different percentage of regular wages after kind of looking at that base period and the average wages during that time. In addition, I'll mention really briefly, and we might go into it more in other videos, that each state treats intermittent and partial week leave a little bit differently, and some states allow it, some states might not. Usually some form of intermittent leave is going to be available on a day-by-day basis, but again, that varies from state to state. So that's something else that can lead to a lot of difficulties in calculating paid family leave benefits. You have to have an idea of how to calculate it on an intermittent basis. So if you want to supplement those benefits, you can figure out how to do that. The variability in paid family leave laws from state to state leaves some decisions for employers to make. Here are just a few of them on this slide, but there are really many more. First, will the employer provide only the minimum leave required by law, or is the employer going to have a paid family leave policy that provides for more than what the law requires? Well, an employer has options here, so it could provide just the minimum. It could say, we're not really going to have a paid family leave policy. We'll provide whatever the state says we have to provide. If the state says we have to provide 8 weeks, we'll give that. If it's 6, if it's 12, if it's 18, we'll give that. Of course, an employer has to comply with the laws that are applicable in each state, but an employer could provide something more. In some states, providing the minimum means that the employer is just going to provide FMLA when an employee is eligible for it, because those states don't have a paid family leave law that's applicable. In some states, an employer is going to have to provide both FMLA and state paid family leave. Now, all the laws allow that those leave run concurrently if an employee is eligible for both of them. So in most circumstances, an employee isn't going to be able to stack paid family leave provided under state law with FMLA. It's possible that someone could qualify for state paid family leave but not qualify for FMLA. And in that circumstance, they would be allowed potentially to stack their leave entitlements. So an example of that, just real quick, is if someone in California goes on leave to care for a sibling under the California Family Rights Act, caring for a sibling isn't a qualifying reason for leave under the FMLA. So an employee could get 12 weeks of leave to care for the sibling, and then could take 12 weeks of leave under the FMLA to care for a parent, child, and spouse. So, the contours of leave stacking aren't always addressed very well in these laws, but generally, if someone qualifies and is eligible for leave under two laws, an employer can require that the employee exhaust leave concurrently, and an employer will want its paid leave policies to say, hey, all the leaves that are available to you are being exhausted at the same time. You can't stack leaves, because we think that, if you stack them, it would be unfair to employees in different states who don't, get that ability to stack, and because we just want to provide you with a fair amount of time off. Another question an employer has to ask is who will be eligible for paid family leave benefits. An employer might not want to make those benefits available to employees on day one. In some states, they may be required to make them available on day one because the threshold for eligibility for employees is so low and so expansive and so broad. If an employer wants to, it could say, hey, we're going to make people wait 6 months before they can qualify for paid family leave, and we're only going to provide it to you earlier if a state law requires us to provide it earlier. That's something that a state could do. In addition, an employee might ask, will the employer provide paid family leave, or is it going to provide unpaid family leave? That's another decision that the employer may be able to make in many of these states. Finally, how is the employer going to calculate paid family leave benefits, especially in states where an employee might receive paid family leave benefits from the state? An employer can't pay those employees in a way that's going to create inequality from state to state. Let's look at that a little bit closer. And in looking at it a little bit closer, we want to tell you what we do at Equileave. So we have a calculator that helps employer come up with pay plans for employees based on an estimate of benefits that employees will receive from state programs and from the employer's private insurer and state disability programs. So this enables the employer to supplement the employee's hourly wages up to 100% of their usual salary or hourly weekly wages. If an employer doesn't, make those supplemental calculations, it's going to have trouble deciding how to implement its paid family leave program. So this is a calculation that an employer would do if it wants to provide paid family leave. If an employer says, hey, we want to give a right to employees to take paid family leave, and we're going to provide that in states without a paid family leave law. We're going to say, hey, your state maybe doesn't have a paid family leave law at this time. Maybe it will in the future. Maybe it never will. But we as an employer are going to pay you when you're on a leave to bond with a newborn child. So the fact that some states have state benefits that provide wage replacement to employees makes it kind of hard for employers to figure out how to equitably pay people who are on a paid family leave in multiple states. So especially if an employer operates across state lines, this can get really, really complicated. So imagine if an employer has a paid family leave policy and the employer wants to be sure that everyone gets 100% of their regular salary or hourly rate. Well, in those states with PFL laws, if an employer just paid everyone 100% of their salary or hourly wages, the employer would be in trouble because those employees are also going to get state wage replacement benefits at some percentage of their compensation. So employees in those states would kind of be overpaid. They'd get a windfall. They'd get more money when on a paid family leave in those states. And then employees in other states without those laws would kind of be underpaid. They just get their regular compensation, which isn't good. And in those states with PFL laws, an employee could be ineligible for benefits if an employer makes those overpayments, which isn't good either, because then the employer and employee maybe have paid into this tax, funded system, and then they're not getting the benefits back when they qualify for them, which is going to result in some losses that no one wants to experience and don't make sense. So you want to make sure that people are paid equitably across state lines, and properly calculating the supplemental amount to pay an employee in those states with paid family leave laws can help ensure that an employer is doing that. All right, so that is our presentation today on paid family leave. As you can tell, our thesis kind of was that these laws vary a lot from state to state, and employers are going to really have to think carefully about how to administer their programs, how to write their policies, and if they're going to have a paid family leave program, how are they going to manage the supplementation of the benefits that an employee might get from their state programs? And again, that's what we try to help employers do at equileave.com, because we know employers want to provide equitable leave benefits across multiple states. So if you have questions about that, please visit our website where you can try out our calculator and our product and learn more. In addition, you can email us at admin@equileave.com if you have questions. I'll just say too, we have a lot of resources on our website and in our blog that try to provide you with the information you need to empower your paid family leave program. We have sample policy language, we have checklists, we have questions, we have guides, we have information about the different state paid family leave laws that are out there and that whole landscape. So really encourage you to check out our website for more information. And if we can do anything to help support your paid family leave program, please email us so that we can connect and learn how we can help you. Thanks for watching. I hope this was an informational video on paid family leave and the overview of the landscape of laws throughout the United States. If you have any questions, we hope to hear from you, and we hope to see you in another webinar. Thanks, everybody. Have a great day.